First of all, good afternoon. I'm Lita Anthony, and I'm the chairman of the Central Arkansas Reentry Coalition. First of all, I want to express our appreciation for you being here, especially our judges and those who are running for judgeships, because we know this is a busy time in your campaign. But we feel that this work is equally important as we have opportunity to hear from you in an informational forum. So thank you again. And for those of you who have taken time out from your Saturday afternoon to be a part of this, thank you. I also at this time need to recognize the other partners who are supportive of this particular forum. City of Little Rock, Racial and Cultural Diversity Commission, Americans for Prosperity, NAACP, Little Rock Chapter, Central Arkansas Alumni Chapter of the Delta Sigma Theta Incorporated, and of course the Arkansas Homeless Coalition. Thank you so much for being a part of this. We also at this time want to again keep this moving so that we can hear from those of you who are candidates. So I need to at this point introduce Erica Benedicto, who is the Director of Racial and Cultural Diversity, City of Little Rock, for the introduction of our moderator for today.
Good afternoon. As Lita said, my name is Erica Benedicto, and I am the Diversity Program Manager for the City of Little Rock's Racial and Cultural Diversity Commission. And we're so pleased to be a partner in planning this event. We love giving citizens the opportunity to civically engage with candidates, particularly judicial candidates this time around, and to actively participate in their democracy. I do want to give a special thank you to our moderator this afternoon. Her name is Laura Monteverdi, and you may recognize her from KTHV 11. She anchors the morning show. She also has a show that she anchors called The Vine, and it is a lifestyle show that focuses on the community. So thank you again for moderating, and we'll just turn it over.
Okay. All right. Thank you all so much for having me here this afternoon on a Saturday. Appreciate that. So we are going to get this rolling this afternoon. I always want to say morning because I'm a morning girl, but I'm in the afternoon zone now. So just to go over a couple of rules with you this afternoon. As a reminder, this is an educational event only and an informational event. So that means no campaigning, no electioneering here today. We are here to get educated. Each candidate, when they come up, will be allowed a 1-minute bio so they can give a little bit of information about themselves to the community. Also, each candidate will be given up to 2 minutes for their question. Whoever answers for the first question will answer second for the second question. And if there are any questions from the community today, we were asking for those as they came in, and those will be vetted beforehand. We will be able to give those to them at the end of that category. So let's get this ball rolling this afternoon. And I would like to invite up for Circuit Judge District 6, Division 2, Subdistrict 6.2, Casey Tucker, Hugh Finkelstein, and Scott Richardson. If you could come up to the stage. And Casey Tucker, I believe, is not here today. Okay. So we have Hugh Finkelstein and Scott Richardson. How are you doing today, gentlemen?
Doing well.
Doing well? It's so quiet in here, we can hear a pin drop. Well, I'm also going to point you to the direction of my lovely ladies in red in the front. If you could wave your hand. These are your timekeepers today, and I'm told they are very tough and very loud. So be prepared for that. They will keep us on time. You guys ready?
Sure.
Okay, let's do this. So the first question, Hugh Finkelstein, if I may start with you. What is the most important quality in a judge, and do you possess it?
Well, the most important quality of any judge is fairness, and I think that goes across the board. You have to be able to listen to all the evidence. You have to remain neutral, keep your mind open, and then make a fair decision based on the law, based on the facts, and not based on who the parties are, how much money they have, who the lawyers are, or any of those factors. That's the most important aspect that a judge has. I do have that. I was district judge in Little Rock for 2 years. I was appointed to that position, and during that time I was selected Judge of the Year both years by the Pulaski County Bar Association, basically the people who sit and judge you when you're judging the cases. So I believe I do have that fairness. And I have 2 minutes left, or I think I'm up. But, okay, I will say, my name is Hugh Finkelstein.
I apologize for that.
With Monteverdi.
You got it.
It's tough to do that. But that's who I am, and I'm running for 2nd Division Circuit Court.
And I will allow you, see, I already messed up, so we're all good here. I'm going to allow you your 1 minute, too, for your bio, if you want to go ahead with that.
Well, if it's okay, let Mr. Richardson answer, and we can do the bios after.
Let's do that. If that's okay with you, Mr. Richardson, I'll ask you the same question. What is the most important quality in a judge, and do you possess it?
I wouldn't nail it down to one. I think there are several things that a judge needs. He needs to know the law. He needs to know what the burden of proof is, whose job it is to prove their case, and he also needs to know what's right. I've practiced civil litigation for the past 18 years, which is what this position will handle. I've handled all manner of cases, contracts, car wreck cases, products liability cases, even trade secret cases. And I've also always kept a docket of civil rights cases, which I think helps me on that last touch of knowing what's right and how to be fair. Those civil rights cases have taught me about institutional bias, how to identify it, and how to manage it in a courtroom. And so that gives me that experience to bring to the bench so that I know what to look for to ensure that people are heard fairly, of whatever race, whatever color, whatever religion, whatever sexual orientation, or whatever background, so that this court remains open for all those people in that position. I've also spent 10 years at the Attorney General's office under Governor Beebe and Dustin McDaniel. That helped me to understand more about governing. I worked with the legislature and know the difference between having positions that you're pressing and trying to look for what's best for people. And so I think those are qualities that lend me, I know the law that this court will use, I know who bears the burden of proof, and I know what's right. I'm also an Eagle Scout too, by the way. That helps on the right angle.
All right. And gentlemen, just a reminder too, we are streaming this as well. Just if you want to hold the mic up, if everybody can hear okay in the back. Thank you.
Right.
And you can go ahead with your bio now. You have 1 minute to do that.
All right, my name is Scott Richardson. I'm a lifelong resident here in Pulaski County. I'm a Christian, a husband, a father, small farmer, and a lawyer for the past 18 years. 10 years of that was under the Attorney General's office with Governor Mike Beebe when he was Attorney General, and Dustin McDaniel. I also served twice as a Special Associate Justice on the Arkansas Supreme Court, and I also do hearing officer work for school districts. I do a lot of education law working with the Jacksonville, North Pulaski school districts. A hearing officer helps school districts, and I do this around the state, when they exercise their judicial function of deciding whether or not to terminate employees' employment, whether or not to expel a student, or to hear grievances from teachers as they come forward. And so school districts will hire me to help them manage that judicial function they perform.
Thank you.
As I said, my name is Hugh Finkelstein. I'm running also for 2nd Division. I'm a father. I have 2 grown children, 25 and 26, 1 grandchild. He's 2 months old now, and we try to spoil him as much as we can. I am a Christian. My wife, Ginger, is here. We attend and serve at New Life Church. We used to go to the Greater Little Rock campus. Now we go to the campus in West Little Rock. I've been a lawyer 28 years. I was in private practice and handled every kind of case all over the state. I've been a prosecutor. I'm the chief deputy prosecutor in Conway. As I said, I was a district judge for 2 years. I've been associate justice of the Supreme Court on 2 separate cases, and I know exactly what it takes to be a judge because I've been a judge. I know what it's like to be a lawyer, and I know what it's like to actually have these cases matter because I've been in a case that will be just like cases that are handled in 2nd Division. And I know exactly how it feels to hope the judge gets it right. I see my time is up. Thank you.
Thank you, gentlemen. For our second question, and Mr. Richardson, if you would like to answer first for this one. How will you react when you are asked to apply a state or U.S. Supreme Court precedent with which you disagree? Is it ever appropriate to not apply it?
Circuit courts apply the rule of law, and they stand in between the power of the state and the people, and that apply that check on the power of the state is we rule on the rule of law, and people need to rely on that rule of law. So if there are cases that I would disagree with, I'd have to put aside that personal bias and apply that rule of law. Now, there are some ways that if a judge feels a law is unjust or is unjustly applied, he can make that known. At circuit court level, we don't have the opportunity to address laws in the same way the Supreme Court would, or precedent the same way the Supreme Court would. But you can, in your opinion, let the court know, that higher court, what your opinion of that law is, or if it's oppressive or overly harsh on people. So that's the perspective I would bring. I've been involved in cases where we've challenged the constitutionality of laws or defended the constitutionality of laws. So I've written briefs and argued to courts on those matters, so I have a lot of experience with that. In fact, I handled one case at the Arkansas Supreme Court where I was arguing for the state when I was with the Attorney General's office, and the court agreed with me and decided my way, but I kind of felt like that went a little bit far, and a few years later, the Supreme Court addressed the same question again and limited that prior case, and I thought that was the right result. So I've actually been in this situation where I've had to advocate for a position that I was a little concerned about. But in a court of law, you apply the rule of law because that's what's fair, and people's expectations are met when they come to court. When people come to court and the court does not apply the rule of law, it applies its own personal opinion or bias, it becomes very hard for people to order their conduct, especially businesses and individuals. So I think that's very important. It's one of the reasons that I'm running for circuit judge.
Thank you very much. Right on time. Mr. Finkelstein.
Thank you.
Would you like me to repeat the question, or you?
I think I can get it.
Okay.
Basically, Mr. Richardson is correct, and this is an easy question because judges can't impose their personal feelings and beliefs over what the constitutionality of the law is. And we do it all the time. I've been a lawyer 28 years, and I've represented the state, I've represented individuals, and there's been plenty of times that I've thought the law was wrong. And I argued that, and I made my record, and we appeal it, and we hope that the courts of appeal and the Supreme Court get it right. But as a circuit judge, you don't have that option. You can't say, well, I'm going to abide by my own personal feeling and override what the law is. You can do what you feel is correct, what you feel is legal under the law, and that's limiting. If there's Supreme Court justice candidates that are coming up, and they'll have a chance, I'm sure, to talk about their views on that. But with circuit judges, when there's precedent, we're limited in what we can do. What we have to always look at, though, is this really a precedent? Is this really something that has already been decided? Because a lot of times there's cases that say, well, in this situation you can do this, but if we're looking at a case that is factually different, then we're not bound by the precedent of what was done before. We have to look and see and determine whether this is a factually the same case or different. And in that case, you have to make your decision once again on the facts and the law. And you know, like I said, I've been doing this 28 years. I've represented victims of crime. I've represented defendants in civil actions and plaintiffs in civil actions and defendants in criminal cases. And we always look to be fair to our clients and fair to the system. And that's what I would do.
Thank you. Were there any questions at this time that were taken from the audience beforehand? We have one question, from what I understand.
This is a family court question. What is your opinion on 50-50 joint custody, and do you support a rebuttal presumption of 50-50 custody to fit parents?
You can go first.
Okay. That, under the law in the state of Arkansas, 50-50 joint custody is the presumption, and I certainly believe in it. I've gone through that situation where my 25-year-old son he was very young when my ex-wife and I got divorced, and we worked up to 50-50 visitation, and I think that works well because a child needs both a mother and a father in their lives to have the best chance of success, and I think that when parents work together to help the child and they're able to communicate, the child's going to have a better chance of success. So I do believe that that should be what we look for as judges.
That is true that now the 50-50 is the presumption in the law. That wasn't true for a long time, and often one side got the benefit of more visitation. I'm actually a guardian ad litem. I've gone through that training and can serve as an advocate for children in the courts. And I can tell you, for children in the courts, this is a tough situation. They do need both parents. A child does best when they have both parents involved in their lives. Unfortunately, in domestic situations, oftentimes that's not an option for the child. As a judge, I would look for that because overall, what you're applying is the best interest of the child standard. So when you're looking at the child and what's going to happen in that child's life, you're trying to figure out what's best for that child. So that presumption is there, but if the best interest of the child override it, then we would have to look at a different arrangement. And whether that would be more time with the father, more time with the mother, you have to look at each individual case.
Thank you very much, gentlemen. We appreciate you being here today. For our next round, we have Circuit Judge, District 6, Division 8, Subdistrict 6.1. Tawana Bird and Suzanne Lumpkin, if you could come to the stage. Just you today? Appears to be. Well, that is perfectly okay. At this time, I'd love to give you the opportunity to share a little bit about yourself. You'll have 1 minute to do that.
Thank you. Good afternoon. My name is Tawana Bird, and I am a candidate for 8th Division Circuit Court. That court is currently occupied by Judge Wiley Branton. I've been in practice for 23 years here in Pulaski County, and my practice has been very diverse. I have practiced criminal law, I've done a lot of juvenile law, and some family law, and some administrative practice. My current practice has been open for 10 years, and I also have a few other jobs. I'm the public defender in Sherwood. I'm an assistant city attorney in North Little Rock. I handle Civil Service Commission and truancy, and I am also an attorney ad litem. I represent children in foster care in Poinsett County, Arkansas. The juvenile court covers 3 areas. I have experience in all 3 of those areas, both as an attorney litigating those cases and as a special judge overseeing and hearing and ruling on those cases. It is my desire to serve in that court because I believe I'm best qualified to do so. Thank you.
Thank you so much. Would you like to go first?
Yes.
Okay, that's an easy question. Your first question today is, what is your philosophy on constitutional interpretation, both state and federal?
This is one of those hard questions. I do not consider myself a strict constructionalist. I do believe that each case, as the candidates before me said, has to be determined on a case-by-case basis. You have to apply the facts that you have and apply the law to those facts that are before you. Although there are times when the law is not clear, and although the Constitution says what it says, you all are well aware that there are often times that those constitutional things are changed or overturned. I do believe that I have to give consideration to what the Constitution says right now and what is currently in place, but because every fact pattern is different and every situation is different, on a case-by-case basis, I'll have to make a determination about whether the situation is constitutionally sound or not.
For your second question today, what are the most important factors to consider when faced with a case of first impression?
The most important factors to consider are any precedent that's out there, persuasive or otherwise. I think courts have the ability to look outside of the jurisdiction that's hearing the case, because if there's no law that has been established in the state, you can look on a federal level, or you can look to other circuits who've made decisions that relate to the fact pattern that is before the court. And then sometimes you have to be really creative, but there are other opportunities to look at persuasive law from other circuits or on the federal level that may apply similarly to the fact pattern that is before the court. So on a case of first impression, you listen to what you have and then look for law that may align with the pattern that's before the court.
Are there any questions from the audience that were pre-approved?
Please.
I don't believe there were any questions at this time. Thank you so much for joining us this afternoon. All right, our next round is Circuit Judge District 6, Division 9 at large. I'd like to invite up LaTanya Laird-Austin and Judge Andy Gill. You guys can give a round of applause if you want every time. Get some noise in this room. How are you doing today?
I'm great. How about yourself?
Great, thank you. How are you doing?
Doing well.
All right, you guys ready for this?
Yes.
Okay, they're not as mean as I thought, right? They're pretty nice. They're pretty nice. Okay, so I will give you each a minute to go ahead and tell a little bit about yourselves. Whoever would like to go first.
I'll start. Good afternoon, everyone. I am LaTanya Laird-Austin, and I am a proud resident of Pulaski County, born and bred, graduate of the Little Rock Central High School in 1994. And of course, I'm running for Division 9 Circuit Court. I do have a judicial philosophy. That question probably won't come up again since, oh no, we hadn't had that judicial philosophy question. So it may come up, but you can find me on social media. You'll see all that. I'm a wife, I'm a mother, and some say I'm a good friend. And I'm excited about the opportunity to run for a circuit court judge. I've been practicing for 17 years here across the state of Arkansas, and I've been a public servant for just about all of those years. I look forward to the opportunity to serve you in the capacity of Pulaski County Circuit Court Judge. I currently own my own law practice. I see I've got time here in Pulaski County, and also work for Center for Arkansas Legal Services. Thank you.
Thank you so much.
Hi, good afternoon. My name is Judge Andy Gill. I've been a district judge for the last 7 years. I've been practicing law for about 15 years now. I am a husband. My wife, Mandy, and our 2 kids are actually at a basketball game right now, so they weren't able to join me this afternoon. I was excited to see the sponsors of this group when I was making plans to be here, because reentry is something that has been a part of my professional life even before I was a lawyer. Before I went to law school, I worked for the mental health services. I was a case manager, and I worked with people that were transitioning from the state hospital back into the community. As a prosecutor, I've worked with drug courts, and so a lot of my job there was working with people, most of whom have been to prison, most of whom were on parole, and working to get them established in the community in a way that they could be productive members of our society. So I'm pleased to be here, and thank you all for your time.
Thank you so much. Our first question today, and I will direct this to you, Ms. Austin. The criminal justice system has a high number of juvenile offenders. Why is that, and what can courts do to reduce these numbers?
I've been practicing in juvenile court my entire career, and I have seen an enormous number of individuals come through that court. You know, when I was growing up, if there was a schoolyard fight, it was a schoolyard fight. I didn't have a charge of battery in the 3rd degree. I didn't have an obstructing governmental charge. We have, as a society, begun to criminalize so much behavior that it results in an enormous number of juveniles coming through juvenile justice system. I think there needs to be some other resources used in our community to prevent criminal charges when we can use resources such as conflict resolution and different classes, different agencies to reach out to the youth and even some of the parents, because a lot of issues stem from issues in the home. And if we can address those issues to make sure that as juveniles progress through school and as they grow towards becoming an adult, we can teach them how to deal with issues that might result in criminal charges. Again, schoolyard fights, not obeying the rules of the home, anything that gets them into that juvenile justice system. As a judicial officer, it would be difficult for me to handle that before it gets to me, because I can't operate in two different arms of government, so to speak. It would be my job, if the case got to me, to figure out ways to reduce possibly a conviction if there are maybe options of diversion or things of that nature. So, but definitely using our community resources to make sure that juveniles have every opportunity to become productive citizens without coming through the juvenile justice system.
Thank you. Would you like me to repeat the question to you?
If you don't mind.
Sure.
Please.
The question is, the criminal justice system has a high number of juvenile offenders. Why is that? And what can courts do to reduce those numbers?
Well, and really, I would echo a lot of what Ms. Austin said. It's true that we have changed over the last probably couple of generations, where a lot of behavior that was dealt with either within the family or within the school now finds its way into the criminal justice system. And so those are things that I think the judge doesn't really have control over, because they're not controlling what gets filed into their division. But through outreach to the community, to whether it's schools or church groups or others, to make sure that they understand what the other options are, and to encourage those sorts of systems to be in place before they get into the court system. Once they are on a juvenile docket, I think it's important that a judge that handles those types of cases not treat juveniles just like they not treat adults coming into the adult criminal justice system like case numbers, like a docket entry, where judges take the time to try to understand what the problem is, and if they can make decisions in terms of their sentencing that would help prevent this person from coming back into the system. So a large number of the people that are in the criminal justice system, if you've been around it much, are the same people over and over again, whether that's on a district court docket or whether that's in circuit court. And working with smart sentencing and with community groups to reduce those folks, once they've made it to the system, that when they get back out in the community, that they not come back.
Thank you. And Mr. Gill, we'll start with you for this one. What are the most important factors to consider when faced with a case of first impression?
Well, I mean, I would say there aren't too many cases of first impression in a complete way. So almost anything that is coming in front of a judge, you can touch on, or you can look at precedent. You can look at ways that this statute or even the language in the statute has been used before. But in a case of first impression, you're going to go to the plain reading of the statute, the words as they exist on the page, and try to apply those to the facts that are in front of you in as clear a way as possible. In Arkansas, we don't do much with legislative history, and so judges aren't in a position to try to discern what is it the legislature was attempting to do when they made this law. I have had times where I have had things come in front of me where the statute I felt like was probably not, was written in a way that was more broad than I thought the legislature wanted. But that's the way the words were on the page. That specific example is a few years ago, the legislature passed a bill that allowed courts to create a program that would allow people to get their reinstatement fees consolidated down to one reinstatement fee if they completed a class with a court. It was pretty broad, and so in my district court, we started a class. I taught it. It was free of charge, and people could come if they completed that program and brought their reinstatement letter from driver control. We signed an order that allowed them to consolidate however many reinstatement fees they had down to one. Now, that law had a sunset clause in it, and when it expired, when it was repassed by the legislature, it was much more restrictive, and they said that these people could only get that same benefit if they actually graduated from a specialty court. So that confirmed my suspicion that they wrote it broadly on the front end, but that's what I did, because that's the way the words were on the page, and when we had an opportunity to help people in our community, we did that.
All right. Thank you, Mr. Gill. Would you like me to repeat the question to you?
Yes, thank you.
Sure. The question is, what are the most important factors to consider when faced with a case of first impression?
So when I originally think of a case of first impression, I'm thinking about a case where the court has never seen an issue like that come up, particularly as it relates to the current law, where it may be unclear. However, any case that comes before the court in a quirky kind of way is a case of first impression. And I say that because there's no case like the other. And that's based on the facts of the case. And so one of the issues, or one of the Ds, and I have a 3D platform, and one of those is the use of judicial discretion. And if you're talking about using judicial discretion to reach an equitable disposition of a case, every case is a case of first impression. There's no custody case that is just like the custody case that we had on the docket just before it. There is no criminal case that is exactly the same than the criminal case of yesterday, because each one of those cases has something unique built into that case that causes it to be a case of first impression before the court. And one of the ways you deal with that is by looking at the individual that's before the court, looking at resources that are available to handle the issue that is brought before the court, and looking at ways to really provide justice for that individual. And again, that could be community resources, that could be diversion, that could be mediation, that could be a number of things based on the specific facts that are presented to the court for that individual. It's about equity, not equality. It's about finding the difference in that case that makes justice for that particular person meaningful, as opposed to a cookie cutter approach for every case that appears before the bench.
Thank you. At this time, are there any pre-approved questions from the audience? We have one for you guys. Go ahead whenever you're ready.
Check, check. Okay. So this question has to do with the racial disparities in the Arkansas criminal justice system. Question is, are you aware of the ratio of blacks being sentenced and the length of their sentence compared to other races?
Mr. Gill?
Yes, and I'll tell you one thing, the criminal justice system has not caught up all the way, but over the last couple of decades, there's a lot more emphasis on keeping those sorts of statistics so that we can look at the way the system is working and look at ways to solve that. I have one, I guess, short example of that. I was working at a cow's expungement clinic, and there was a fellow there who had a conviction from maybe 30 years ago. It was a nonviolent conviction, but he went to the Arkansas Department of Corrections, which made him ineligible to get under his circumstances, ineligible to get his sentence expunged. So that was a way that I saw what was institutional racism, is my guess, where this case took place and the time that it took place. And it looked like a 19-year-old that probably went to prison for an offense that today would definitely be probation, but 30 years later, it's still affecting him. So even when we're changing laws going forward, we have to look at the past and understand that we have to work backwards to make sure that those harms in the past can be corrected now.
Thank you. Would you like the question repeated?
Yes, thank you.
Okay. Sir, would you mind coming up to read your question one more time?
This question is about the racial disparities in the Arkansas criminal justice system. Are you aware of the ratio of blacks being sentenced and the length of their sentence compared to other races?
Yes, all of my career has been in criminal law. I began my work as a prosecutor, then became a deputy public defender, and then when I opened my practice, became a private attorney handling criminal defense and cases on appeal. Yes, there is definitely a disparity, and here's one of the reasons I think there's an issue with that. It's a socioeconomic issue. A lot of times, people of color are unable to negotiate in a way that keeps them from being able to be free as opposed to incarcerated. And by that I mean, if there are, let's take a theft of property case, and there's an issue of restitution, and someone with the financial means to pay that restitution up front gets the benefit of maybe having that felony charge reduced to a misdemeanor, as opposed to a person of color who does not have the financial means to be able to pay it up front, and they are subsequently sentenced to probation or Arkansas Department of Corrections because of their inability to pay. That's a travesty.
Thank you so much both for your time today. We appreciate you being here. Thank you. Our next round is Circuit Judge District 6, Division 10, Subdistrict 6.1. I'd like to invite Lot Rolfe, Shanice Johnson, and Jonathan Q. Warren here today. Shanice, I believe, is not able to be here today. Good afternoon, gentlemen. How are you doing today?
Good, thank you. How are you?
I'm doing well, thank you.
Fantastic, thank you.
Thank you for being here. So I will give you each a minute to tell everybody a little bit about yourselves. If you would like to go first, Mr. Warren.
Thank you all for having me today. My name is Jonathan Q. Warren. I am running for 10th Division Circuit Court, which is a juvenile seat currently occupied by Judge Joyce Williams Warren, who is going to have to retire due to an age provision. I am currently at Rainwater, Holt, and Sexton, where I've been in private practice for the past 3.5 years. Started my judicial career as a judicial law clerk to the Honorable Annabelle Clinton, now Tuck. Went there to work for the prosecuting attorney's office while I was there for about 5 years. Left there to go to the Attorney General's office, where I worked in the civil litigation department for about 4 years, where I did work doing cases for the state and defending the state. And so I did some inmate litigation in there. I did a fair housing racial discrimination case there, which I think was the first of its kind. I've been appointed by the governor to serve as a special associate Supreme Court justice, and I've been appointed by the Supreme Court to serve as a lawyer member on the Judges and Lawyers Assistance Program, which helps attorneys and judges and their families. And so I did some inmate litigation in there. I did a fair housing racial discrimination case there, which I think was
Time to introduce yourself.
Thank you. And good afternoon, everyone. My name is Lot Rolfe. I'm a lifelong resident here in Pulaski County. I grew up here in Little Rock. I've been married for 24 years to my wife, Terry. We have 2 children, ages 20 and 17. I've been practicing law here for 22 years. I'm in private practice currently right now. When I started my legal career, I first worked at the Little Rock City Attorney's Office, and then I moved over to the Arkansas Public Defender Commission, where I've represented individuals on every level, from district court to juvenile court, and even on the capital level, representing individuals who are facing the death penalty. I've traveled all over the state of Arkansas, representing individuals and families with their various legal situations. I believe that I'm the right candidate for this judicial seat because I believe there is a need, serious need for juvenile justice reform in this state. I believe I'm the best candidate to do that.
Thank you, gentlemen. Mr. Warren, I'll begin with you. Okay. Who is your judicial role model and why?
I had a feeling I was going to get this question. I've practiced in front of a lot of great judges, starting off with Judge Hale in Sherwood District Court. Judge Munson and Judge Lytle went to Circuit Court, practiced in front of Judge Piazza, then went and practiced in front of Judge Leon Johnson, then practiced in front of Wendell Griffin in 5th Division before I went to the Attorney General's office. The easy answer to that is my judicial role model is my mother, whose seat I'm seeking. And for lack of a better phrase, since 1983, since she got appointed to the bench, I've had a front row seat to see what it takes to be a judge who is fair, ethical, compassionate, and does the right thing on a daily basis. And so she, without question, is my judicial role model.
Thank you. Mr. Rolfe, would you like me to repeat the question?
I can remember the question. And, you know, there are a number of judges I've been before who I enjoy practicing in front of, but I think probably my judicial role model is retired Judge Marion Humphrey. I've had an opportunity to practice in his court, and I just think what I've seen from him, both inside the courtroom and outside of the courtroom, is somebody who I really want to model myself after. He shows a lot of intellect, or showed a lot of intellect on the bench. He was firm when he needed to be, but he also showed a lot of empathy or sympathy for individuals who came in his courtroom. And so that's somebody who am able to obtain that position on the bench, somebody who I would like to pattern myself after.
Thank you, gentlemen. The second question, Mr. Rolfe, would you like to go first? Sure. The second question is, how will you react when you are asked to apply a state or U.S. Supreme Court precedent with which you disagree? Is it ever appropriate to not apply it?
Well, and I think the other candidates stated earlier, obviously at a circuit court position, there is a level of restraint that we would have to adhere to and follow. But, you know, we cannot forget also that there are times that there may be a need for activism, especially if the law is not clear, and that sometimes circuit judges will need to step out and make decisions that may not be popular, you know, in society as well. But our society changes. Our Constitution is a flowing document that moves depending on what's going on in our society. And so we know in our long history there have been many laws that have been passed that have been unfair to minorities, that have been unfair to women, and it takes judges to step out there, you know, for certain things to change within our society. So yeah, so while we do want to practice restraint, at the same time we also need to be mindful that as society changes, we need to make sure that we have judges in place who are not afraid to step out there when they see that something needs to change in our society.
Thank you. Mr. Warren, would you like me to repeat the question?
No, thank you. I've got the question. I can't disagree with anything that Mr. Rolfe said. I can't disagree with anything that the prior candidate said. But what I do have to say is, by the code of judicial ethics, should I be elected, I'm going to have to take an oath to uphold the Constitution of the state of Arkansas. I'm going to have to take an oath to uphold the Constitution of the United States. So I pledge to follow the law and follow the code of judicial conduct and ethics. And so every case will be a case-by-case basis that you'll have to analyze and make the right decision on that. So I pledge to do that and pledge to do the right thing on every case, especially in this juvenile seat, which I feel, no disrespect to Mr. Rolfe here, but I do believe that I am the best qualified candidate for the position, just as he feels he's the most qualified, or he wouldn't be running either.
Thank you, gentlemen. Do we have any questions at this time? I recognize you. Come on up. No shame. Got some questions. Whenever you're ready.
Got to ask these questions, you know? All right, so this is another question concerning racial disparities in Arkansas criminal justice system. What are your solutions for decreasing racial disparities with the youth in the community that come to your courtrooms?
Would you like to go first, Mr. Warren?
I would. Osiris, thank you for that question. In a juvenile seat, which this one is, the school-to-prison pipeline is a real thing that needs to be addressed. I was looking at some stats, and I've been studying this, and for something simple, let's say like a status offense, which is an offense that's just basically by age, black children are about 270% more likely to be affected than white kids. 16% roughly of black kids are in public schools, while 31% are arrested. I've already taken mechanisms into place during my campaign, talking to clergy members, talking to law enforcement people, talking to community members. You got to get everybody on the train. Should it be me elected or be Mr. Rolfe elected, neither one of us can do it by themselves. It's going to have to take a communal effort for everybody to jump in and say, hey, let's help the kids and let's keep the kids out of court. And if they get into court, we're going to do the best we can to make sure that things are going right. But again, I feel like I'm the best candidate for the job.
Thank you. Would you like the question repeated?
Oh, I remember the question.
Okay, go ahead.
And Mr. Warren mentioned the school-to-prison pipeline, which has been my platform ever since I announced my candidacy back in April of last year to work toward dismantling that pipeline. And while there are various things that we can do, one of the things that I think we really need to focus on is ending the weaponization of our courtrooms as it relates to our young people. Many times now we want to use the court system as a way to discipline our young people, okay? And we need to work toward finding alternative solutions as relate rather than using the courtroom to discipline them. There's some things that I still think that the schools, community leaders, things of that nature can work toward helping us find solutions, those nonviolent offenders, to keep them out of the courtroom through other programs, diversion programs that I think would be more beneficial to them than bringing them into a courtroom that I think can cause more trauma to them as opposed to actually helping them.
Thank you, gentlemen, for your time today. We appreciate you. Our next round is Circuit Judge District 6, Division 10, Subdistrict 6.1. Andy Ballard, Sean Johnson, and Tom Barron. Thank you so much for being here today.
Thanks for having us.
Yes. Are y'all ready to begin?
Ready.
All right, let's do this. You look very casual. I like that. Okay, so I'll give you gentlemen a minute rather, to go ahead and introduce yourself. Mr. Johnson, if you'd like to go first.
Sure. Hello, everyone. I'm Sean Johnson. I'm a candidate for 14th Division Circuit Court. I'm a rule-bound public servant, and I believe that public service is something that we all need these days in order to help protect people. It's something I care about a great deal. I, at the age of 13, came from a broken home. My parents suffered a divorce, and it was one of the most important aspects of my life and my development and my character. I clung to Boy Scouting, and I ultimately became an Eagle Scout. It was a thing that helped to shape me. It was the rules. It was what I knew. And then after that, and after law school, I went on and clerked for a federal judge, where I learned how to manage a courtroom docket, and that was important. And he's my role model, by the way, Robert T. Dawson. But then after that, I came to the Attorney General's office. I've now been there for 12 years. I have worked hard to fight robocalls. They're terrible, and I've been fighting those. I have fought the opioid crisis by trying to hold the manufacturers of this country liable for the terrible problem they have caused us. But I've also worked to lower prescription drug prices and just got certiorari in a case going to the U.S. Supreme Court 2 weeks ago, and so I'm a practitioner. So thank you very much.
Thank you. When you're ready.
I'm Tom Barron. Thank you all for having us. I'm a Little Rock native, a third generation Little Rock attorney. Little Rock is my home, and I'm committed to helping our community. A circuit judge is a trial judge, period. So a circuit judge needs to have real-world trial experience and be capable of handling any type of case that comes before him or her. I have that experience. I practiced in our circuit courts for 35 years, including serving as a special judge. I have heard every type of case that a circuit judge might hear, be it civil, criminal, probate, or domestic. Over the years, I've kind of learned how the system works, where the problems are, and how to address them. And one of the biggest problems we're facing is this drug epidemic. It's not getting better. It's destroying our communities. We've tried to arrest our way out of it, but all that's resulted in is a disproportionate number of minorities being jailed, serving more time on occasion than murderers and rapists. We need to address that. We also need to address access to justice.
We are unfortunately out of time, but we're going to go ahead with the first question, and you are first. Are you ready?
I'm ready.
Okay, Mr. Barron. The question is, many critics have raised concerns about cash bail, alleging that it disproportionately affects the poor. Do you agree? What factors would you consider when setting bail amounts for defendants? Would you take into account their ability to pay? It is a lot. If you need me to repeat it, please let me know.
No, I think I know the question, and the question is about cash bail, and
the fact is, when it's used, it can be punitive when it's used. In my opinion, bail can be used to secure somebody's appearance, and you need to do that for a violent offender or somebody charged with a serious crime. But if it's a lower level crime, a misdemeanor, it does have an effect on that person. They can't pay it. They're going to jail. They're going to lose their job. That's going to affect their families. So yeah, in my opinion, there's a lot of cases, probably in most cases, we could just do away with the cash bail. It doesn't serve its purpose anymore, and it's used punitively.
Thank you so much. Mr. Johnson, would you like me to reread the question?
I think I've got it.
Okay.
Just briefly, the answer is that ability to repay should always be something that we take into account, and it's important. We know that even as consumers, when we buy something, the tax on it is the same regardless of how much money you make. So those are things that don't really help people who are at the lower end of the socioeconomic scale, and we need to take that into account at all times. So yes, ability to repay is an important consideration.
Thank you, gentlemen. Our next question is directed at circuit judge nominees. What are the most important factors to consider when faced with a case of first impression? If you'd like to go first, Mr. Johnson.
Sure. I've had one of these as a lawyer, and it was an issue, and I don't want to bore everybody to death, but it was about Medicare Part D preemption. And the issue is, just to tell you from a lawyer's perspective how that works, when you don't have anything to look at to tell you the answer, you have to figure it out. And that means you have to look at the ways that courts have applied that principle in other ways. Even though it didn't deal with Medicare, I had to look at all kinds of preemption cases. Preemption, by the way, is the idea that the federal government takes over whenever they have a rule on an issue and it overcomes the state's rule. So I had to figure that out. You have to look at precedent. If you don't have precedent, the law tells us we look to other things like usage of the trade. What's it like out there in that area? How are people in business functioning in that way? We can also use reasonableness. What is it that would make sense here? And then apply that rule. So as far as a factors analysis, it's really just a matter of being a lawyer. We learn this in law school. It's a matter of looking at various factors, dealing usually with precedent and being bound by those.
Thank you so much, Mr. Johnson. Would you like me to repeat the question?
No,
Okay.
I understand the question. I don't disagree with how the other people have answered that question. If it's a first impression, to me that means we have this set of facts and it doesn't fit the law exactly, or we want to know if that law applies to this set of facts, and first impression means we haven't done that before. And like everybody else, I think a circuit judge looks, have other circuit judges had this question before, how they decided. Has the state Supreme Court or Court of Appeals decided this question? And then you go outside of the jurisdiction, have other states looked at it? How has the Federal Court of Appeals or even the Supreme Court ever dealt with this? So you got to get guidelines. I mean, the law is, it's kind of governed by precedent. We're bound to do what they have done before us, and anyway, that's how I handle it.
Thank you. At this time, are there any questions that were pre-approved? Come on up.
I'm not answering all these questions either. These are definitely from the audience. So I slipped a couple in there, but it's not all me. So I'm just reading them. This is about the war on drugs, basically. Do you support the Joshua Ashley Pauley Act that if someone calls 911 after an overdose, they will not be arrested?
You can go ahead.
Me?
Sure.
Yeah, I mean, I absolutely support that act. A lot of y'all here know me, and I have a lot of connections to. I'm involved with substance abuse. Find a solution for it. It's close to me. It's close to my family. These days, kids are dying from heroin overdoses, and they've got fentanyl, and kids are overdosing at school, and kids are carrying Narcan. Frankly, I never thought I'd see that in Little Rock, Arkansas, but it's here. So yeah, and what happens, and I've seen this happen a number of times, two people are getting high, one of the kids or one of the people, they overdose, his partner there can either call 911 and stay with him, but what usually happens is they push him out of the car, and they may call 911, but they leave him there. you know. Again, some of y'all know this. This happened to my stepson, and he's still with us. But yeah, the law saves lives. I wish we could convince everybody to apply that law. Kind of hard to do with a 16 or 17-year-old.
Thank you, Mr. Barron. Mr. Johnson, same question. Would you like me to repeat it?
No, I've got it. Thank you very much. I live in fear weekly that a cousin of mine who suffers with opioid addiction and particularly heroin addiction could potentially suffer another overdose and not be saved. And we have to have tools in the state like the legislature adopted. I was there in that Senate committee hearing when that statute went through, when that bill was proposed and went through. And it was one of the most common sense pieces of legislation that we could have, Osiris, and it was going to be very helpful. I would like to know that when my cousin has suffered his overdose, that there would be somebody there who wouldn't feel the need to run away. And those laws, as a judge, are laws that we will uphold. In theory, those are laws that we are bound to uphold, much like Mr. Warren was saying, upholding the Constitution. And that's what that statute is for. So, yes, sir. Thank you for the question.
Thank you, gentlemen. We appreciate you being here today. Thank you. Thank you so much. Our next round is Circuit Judge District 6, Division 15, Subdistrict 6.2, Amy Dunn Johnson, Jay Hsu, and Gary Rogers. Thank you all so much for being here today.
Thank you.
So we are going to start, if you notice, with your bio, if you would like to go ahead first.
Sure. My name is Amy Dunn Johnson. I am running for 15th Division Circuit Judge, a position that's currently held by retiring Judge Dick Moore. I'm almost 18 years into my practice as a lawyer. I have been both in private practice and public service. I've represented clients ranging from large corporate healthcare systems to individual clients without the resources to pay. For the last 10 years, I have worked for the Arkansas Access to Justice Commission, which works to make sure that folks who need access to our court system to solve their problems have that access regardless of how much money they have, where they live, or who they are. I've been very involved in the community. I'm a co-founder of Harmony Health Clinic and currently serve on the task force that oversees the Racial Disparities Project at the Bowen School of Law. I have 3 beautiful daughters who are my campaign staff, and really just appreciate you all being here today, and thank you.
Thank you.
Yes, my name is Jay Hsu, and I'm also running for the 15th Division, and I appreciate y'all being here and hosting us to be here today. I've practiced law, I guess I'm in my 24th year this year. I'm a husband. My wife and I have 3 children together between the 2 of us. I started off as a prosecutor. I was a deputy prosecutor for 10 years, and then I worked in the Attorney General's office. I was the director of the Medicaid Fraud Control Unit. After that, I was appointed by Governor Beebe to be the state's first Medicaid Inspector General and created that agency. After that, I went to a large law firm, Wright, Lindsey & Jennings, and for the past 3 years, I've had my own law firm, Hsu Law Firm, where I represent mostly healthcare providers. I think this opportunity to run for judge is an extremely important position, and I think that you will see some differences between these candidates. And I think there are 2 things that I would really want you all to remember as you listen to us. Public trust encompasses both, but someone that's got the trial experience and the public servant experience, which is the majority of my legal career.
Thank you.
I know my time's up.
Unfortunately, we're out of time, but thank you for that. Our first question is for you, Mrs. Johnson. Please describe your judicial philosophy in 1 sentence, and you can explain.
Okay. My judicial philosophy is that, oh gosh, this is kind of tough to sum up in 1 sentence. I believe in the separation of powers, and I believe that it is the role of the court to interpret the law and not to make the law. And I would further explain that by saying that I realize that our Constitution, I realize that both our state and federal Constitution are living documents, and that circumstances change over time, and the society changes, and that it's when you interpret the law with that in mind, I think that's I'm kind of getting. But yeah, that would be my judicial philosophy.
They're tough questions. I did not come up with them. I'll just say that. When you're ready, Mr. Hsu.
Sure. And I think you said that we had to give our judicial philosophy in one sentence.
In one sentence, and you can explain.
I'll explain.
Yeah. I'll do better than that. I'll do one word: consistency. And the reason why I say that that's important, as a practicing attorney and a litigator for the past 24 years, it's very important not only for the lawyers that go into a courtroom, but also for the participants and the litigants to understand what the expectations are going to be when they go into the court of law. And therefore, everyone needs to be treated equally under the law. So the same facts and circumstances are not going to exist in every case. The law should remain the same in every case. Now, there are variances, and we've talked about discrepancies, whether it be minorities or any type of minority, whether it be male, female, whether it be racial minority, what part of the county you live in, it doesn't really matter. But I believe that it's important for the citizens and as a public servant, and to keep the public trust of you all, which is what I've had experience for almost 20 years, that you can expect consistency. So you know, and so the lawyers can advise their clients, and so the clients will know, and jurors, when you have a jury trial, that everyone understands that there's going to be a consistency with that judge. And I would be someone that you all would be proud of for the next 20 years, the last 20 years of my legal career, to be your judge.
Thank you both for answering that question. Our next question is directed toward your race specifically. And I will start with you, Mr. Hsu. How will you react when you are asked to apply a state or U.S. Supreme Court precedent with which you disagree? Is it ever appropriate to not apply it?
And I appreciate the question, and I know that this question has been asked of some other candidates previously, and so I don't want to repeat a lot of the things that they said, and I agree with a lot in the fact that we cannot take our personal beliefs, and that goes right into what I just said before, consistency. Our personal beliefs, it has to be based on the law, and so certainly there are laws over the years that I have disagreed with. I do practice out in front of the legislature. I do government relations, lobbying work, and so I'm very involved in that process. On the government side, I've been involved in helping to create laws, to help pass laws that would be better for our citizens, and what I believe to be better for our citizens, and some of those laws have passed. I don't think, so we all as lawyers take an oath, but as a government servant that I've had a lot of experience for you guys, we take an oath. We swear to uphold the laws, not only of our United States, but also of the state of Arkansas. And so part of that oath is to follow the laws. And so a trial court judge, which a lot of people have talked about this, is to follow the law. There are other ways that people may want to address laws that they feel to be unjust. The Judicial Council is just one avenue for that, where the judges can take their concerns to their governing body and talk about and say, we ought to really talk to the legislature about changing the implication of this law was unintended. It's too broad. It's too narrow. It doesn't work. But as far as applying the law, that's what we would be sworn to and uphold the law. Excuse me. Thank you.
Thank you, Mr. Hsu. Would you like me to repeat the question?
I think I've got it. And I think I would agree with a lot of what the previous candidates have said and what Mr. Hsu has said. You know, I don't think you'll find a judge or an attorney out there who agrees with every precedent that's out there that the U.S. Supreme Court has handed down or the Arkansas Supreme Court has handed down, or that agrees with every law that the legislature has passed. And as judges, we are required to set aside our own personal beliefs. We're required to set aside our own personal biases and prejudices and rule on a case based on the facts and based on the law. And sometimes that may mean that we have to apply a law that we may personally disagree with. I think the second part of that question may have been whether it's ever appropriate not to apply that. And I think the only circumstance under which it would be appropriate to not apply a law that we would disagree with is if it didn't apply to the specific circumstances of the case, if it was something where you could distinguish it from the precedent that you disagreed with. But your own personal opinion about it should not matter if you are acting in a way that upholds your oath to abide by the Constitution and the rules, by the Constitution and the laws of the state and of the United States.
Thank you very much. At this time, are there any pre-approved questions from the audience? Come on up. What is your name, by the way?
Oh, my name is Osiris Bali.
Thank you, Osiris.
All right, so this question is about criminal sentencing. Can either of you explain why a person can be sentenced to the ADC versus the ACC for the same charge?
Would you like to go first, Mrs. Johnson or Mr. Dunn?
I'll be happy to try to do
There you
this
go, Mr. Chu.
because I was a prosecutor for 10 years.
Sure.
So the Arkansas Department of Corrections, ADC, and the Arkansas ACC, the Arkansas Community Correction. First of all, let me say that I believe behind maybe Department of Human Services is probably our largest employer, largest state agency of employers in the state of Arkansas. And that to me is problematic. We have too many people, and I know it's getting into one of the other questions that we were given beforehand, but we have too many people incarcerated in this state. Now, community correction would be parole, and maybe probation, I think, may fall into that as well. But we've got too many people that are in that system. We've got to figure out as a society to reduce the number. We've got to come up with other alternatives for people that commit crimes, but we also can't set people up to fail. I've seen in the past where I'll use methamphetamine. It was a big problem in another part of the state several years ago. It's not as big a problem now, but the sentencing laws were a 70% type of sentence, where some jurisdictions were putting people on probation, and
Thank
then
you,
they would
Mr.
come
Chu.
in.
Unfortunately, we are out of time today.
Sorry, if you'll see me afterwards, I'll try to explain that.
I don't want them to get mean. They might. I don't know them. I just met them. She's looking at me like she might. Okay. Thank you so much both for being here today. Amy, and I will let you. I'm sorry. I was
Sure. No,
just making
that's
sure.
totally fine.
Would you like me to repeat the question?
I think if I remember the question correctly, it's whether someone who, two people with the same charge should be treated differently, and one sent to the Department of Correction and one to community corrections. And I don't think so. I think that Mr. Shu's statement earlier about consistency is very important. And I think that we do have to recognize that when it does come to criminal sentencing, that we do have pretty significant racial disparities. I mean, some of the questions that you've asked earlier and some of the statements that other candidates have offered up, and just the uncontroverted statistics that we do treat people differently and we sentence people differently, and that is unacceptable, and it is contributing to the problem of mass incarceration in Arkansas. Arkansas being, I think, the incarceration capital of the world. So we definitely have to look at ways to be consistent and look at ways, when possible, to provide diversion opportunities so that folks aren't doing time for things that where mental illness or addiction are at the root cause.
Thank you so much, both of you, for being here today. We appreciate you. Thank you so much. Our next round is State District Court 31, Little Rock 2, Peggy Margaret Egan, and Judge Vic Fleming. Thank you both for being here today.
Thank you for being here.
Well, thank you. All right. As always, I guess you can guess what we're going to do now. Allow you a minute to have your bio. So if you would like to go first, Ms. Egan.
Thank you. So my mama named me Margaret. That's what it says on my birth certificate. But then she called me Peggy. And so I go by Peggy, in case anybody's been wondering about that. It's Peggy Egan is what I'm known by. I was born in New York State. Please don't hold that against me. But we moved to Florida when I was a teenager. And I went to school, and I became a high school teacher. And I taught high school for 16 years. And in the length of teaching high school, I said, let me try law school. And I went to law school. And since graduating law school in 2002, I have worked for the Public Defender's Office mostly. And in working for the Public Defender's Office, I've seen quite a bit. I've been in most all the courts in this district, this judicial district, and even some more. And my reason for running for judge is because of what I've seen.
Thank you so much, Peggy.
Thank you.
If you would like to go ahead with your 1-minute bio.
I'm Judge Vic Fleming, and I'm running for re-election to State District 31, Little Rock 2nd Division, a judgeship that I've held for 23 years and 24 and a half days, but who's counting? I want to thank Laura for her time and efforts here today, and I want to thank the Central Arkansas Reentry Coalition for holding this event. I came to Arkansas in 1975 after growing up next door in Mississippi. I went to the Bowen School of Law, where I graduated in 1978. I practiced law for about 18 years before running for and getting elected to the position that I currently have. It's commonly known as Little Rock Traffic Court, although for the last 3 years, in addition to doing all of the traffic cases that start in Little Rock, all of the judges in Pulaski County or District 31 also do 2 days a month in circuit court, where we do domestic relations, paternity, and eviction cases. I've promised honesty, integrity, and to treat everybody with dignity and respect when I was elected in 1996, and I promise more of the same if elected now, so re-elected.
Thank you so much. And I'll start with you, Mr. Fleming. There are high disproportionate rates of minority incarceration. Do you agree? And if so, why do you think that is? Can you take steps as a member of the judiciary to help correct that?
Well, I agree with a lot of things that everybody has said already. Being fair and impartial to each and every person who comes in front of me, treating every case as being a little bit different from dozens to which it's extremely similar, and treating each case because it's going to rise or fall on its own merits. I don't think we want judges saying, well, today I'm going to go in and I'm going to be cognizant of how many people or this race, that race, or the other race. I don't personally know the statistics that show a disparity or anything like that. I can tell you this, out of the court that I preside over, there is no disparity in terms of racial differences because I treat everybody the same. But more than that, with the overcrowding situation in the Pulaski County Jail, virtually nobody out of our court is going to jail for any significant length of time anyway. So I'm not really putting anybody in jail, so I'm not contributing to the disparity, if you get what I'm saying.
Sure.
But by treating everybody equally and fairly, it should work itself out. I think the disparity is more due to the number of people who are charged rather than the number of people who are convicted. And I just do the best I can not to ever unfairly convict someone.
Thank you so much for your response. Ms. Peggy Egan, would you like me to repeat the question?
Yes, please.
Okay, the question is, there are high disproportionate rates of minority incarceration. Do you agree? If so, why do you think that is? And can you take steps as a member of the judiciary to help correct that?
I agree certainly that there's disproportionate representation. And that's not just because I see it almost daily in our local county jail, where I go almost every single day. It's because I see it in the numbers. I've seen enough reports that suggest percentage-wise, the black population is X percent, but the incarcerated rate is 2 times that percent, which means we are incarcerating blacks way more frequently than whites percentage-wise. I also listened to a talk, I think he maybe even spoke at Philander Smith earlier this year, and it was Dr. Kendi talking about his book, How to Be an Anti-Racist. Well, you know, I hadn't thought about it before. But if the ultimate outcome results in disproportionate income, then we can say the law or the application of the law is in fact racist. Now, once again, my opponent just said he has no numbers. I'm all about numbers. I'm about data. I want to know how many people come through my court with speeding tickets. And if only black people are speeding, I guess I'll do special education in the black community. But if only black communities are being stopped for speeding, while as a judge I can't notice that or know that for a fact, I know that I will take particular attention to whether or not it appears that laws are enforced equally where I'm sitting the judge.
Thank you. The next question is specifically for your races. Do you think it's important to consider a defendant's upbringing, environment, and other socioeconomic factors when imposing a sentence? Mrs. Egan.
Well, that was like an easy question. The answer is yes.
I don't make them up.
I know. And that answer is yes, and it's built into the range of punishment permitted in our sentencing guidelines. I'll pick DWIs, for example. DWIs have kind of pretty strict guidelines in that every person convicted of DWI has to do a day in jail. Every person convicted, at least, every person convicted of DWI 2 has to do 7 days in jail, at least. Then you read it a little bit closer and there might be some kind of room for exceptions. But the long and short is, I think I forgot the question.
I can repeat it for you. Do you
No, it's about background. And absolutely, I envision myself sentencing based on information received either from the pro se people, the people in court without attorneys, or the people represented by attorneys providing me information. If you don't have $5, I'm not going to give you a $250 fine. I'm going to find an alternate sentencing approach, because all I'd want as a judge would be compliance with traffic code, safer drivers, safer commuting for me and you, and your background, your skills, your ability to maneuver, period, is what I'm going to be thinking about if I sit on the bench.
Thank you for your response. Would you like me to repeat the question for you?
No, I think I'm good.
Okay.
I think I'm good. Every week in court is on Wednesday mornings when I have teenagers in front of me on a docket that we call our teen docket. I explain the right of allocution. The right of allocution is a constitutional right. It's your right to make a statement to a judge before you get sentenced. And I explain that an allocution statement is, in traffic court, what you might see in federal court as a sentencing hearing. And a judge, having found someone guilty, should take into account all aggravating factors and all mitigating factors to make a sentence match the person and the circumstances surrounding the crime of which he or she is committed. And as I tell the teenagers, the best allocution statement you can make in traffic court if you're pleading guilty to that speeding charge or to that careless driving charge is usually, I'm sorry, I've learned my lesson, I've accepted full responsibility, I'm going to do what I can to never do it again, and I have a good record. And if those things are borne out, then the sentence is light. You tell the judge as much as you can to let the judge give you as light a sentence as possible. The prosecutor's job may be to tell the judge all of the bad things so that the judge gives as harsh a sentence as possible. But it's a case-by-case basis, and the job is to make the sentence fair and meet certain requirements. We very seldom send anybody to jail until they have had a fine, and the fine is usually agreed to by the defendant, because 90 cases are resolved by plea agreement with the prosecutor. And until a person has failed on paying the fine a couple of times, they're then put on community service. If they fail at community service 2 or 3 times, then and only then maybe are they sentenced to jail. And that's usually for non-payment of fines, and the jail won't keep people very long for that. So that's kind of the way we do it. Thank you.
Thank you both for being here today. At this time, are there any pre-approved questions? Here's Osiris.
All right, this is about traffic violations, basically. What are your views on continuing to issue warrants for traffic violations and also suspending driver's licenses?
Judge Fleming, if you would like to go first.
Yes, well, I'd like to thank you for that question, because I'm in the final stages of a law review article that I've written on the issue of failures to appear, and I think that was what that had to do with. First of all, I have approximately 20,000 cases a year in traffic court, and about 20% of those will have a failure to appear on it. There is a statute that allows judges to suspend a person's driver's license for failure to appear. We have essentially stopped doing that on first offense failures to appear, and we also don't suspend licenses if they're already suspended. We're doing everything we can to try to help people and encourage people to get their driver's licenses reinstated. We don't charge failure to appear unless I see prima facie evidence or pretty strong evidence that a person was given actual notice of when and where they were supposed to be in court. That's the best we can do. It's a nationwide problem, failure to appear, as well as driver's licenses. But we're dealing with it as best we can.
Thank you for your response. Peggy, would you like us to repeat the question?
I would. Mr. Volley, I'm so sorry to do that to you.
Osiris, if you wouldn't mind coming on.
I've lost
Come on
sight.
down.
What are your views on continuing to issue warrants for traffic violations and suspending driver's licenses?
Well, of course, I'm not a judge yet, but all I do is see the results of the history, and I'm glad to hear that Little Rock District Court has made it, has focused on reducing the amount of suspended licenses that they give or warrants that get issued. There is a way in my dream world that we get the communities coming to court to be less scary, less painful, but also remind them that we live in a system where we all have to get along, and that's why we establish rules, and particularly traffic court. People need to respect the system as it is, but we need to be more welcoming. Traffic court should be flexible in time. It should be flexible in how it approaches everything. And so I think as far as failure to appears and failure to pays, we can improve a lot by just making people welcome.
Thank you both for your time today. We appreciate you being here. Thank you. Thank you. Very nice to meet you both. Thank you. Our last round is for State Supreme Court Associate Justice Position 4, Judge Morgan Chip Welch and Barbara Womack Webb. Wherever you feel comfortable. Thank you. How are y'all doing today?
Great, thank you.
Good, okay.
We're just living the dream.
Living the dream.
Is this on? Yes.
This is on, yes. Just make sure you hold it a little close so everybody in the back could hear you. Everyone doing okay out there? All good? All right, I see a wave. I see a wave.
Can y'all hear me?
Testing.
We should have done that from the beginning.
That's okay.
All right, I'm going to go ahead and allow you both to give a 1-minute bio about yourself, if you would like to go first.
Sure. My name is Barbara Womack Webb. I grew up here in Little Rock, in Southwest Little Rock, attended Cloverdale Junior High, went on to McClellan High School, which I'm sorry to hear is closing. But I grew up with 4 sisters. And I tell everybody that I can be a good justice that works with the other justices because we shared one bathroom. So 5 girls, 1 bathroom. But I currently serve as the chief judge at Workers' Compensation, Arkansas Workers' Compensation, which is cases where people that are injured on the job come to have their claims addressed and heard by judges to seek medical attention and to seek compensation for the time they miss work. And if they're seriously injured where they can't go back to work or they're killed on the job, to have permanent and total benefits for the rest of their life or for their survivors. So it's a very important system, and I supervise 10 judges that hear those cases all over the state of Arkansas. I personally go to, stop now? Okay.
Thank you, though. Judge Welch?
Thank you. I'm Judge Chip Welch. I've been a circuit judge for the last 7 years in Pulaski County. I'm a general jurisdiction judge, and I've been elected to my position twice. I got reelected last time last year. I'm running for position 4 on the Arkansas Supreme Court as a nonpartisan candidate because I believe that all of the candidates for judicial office should exemplify the notion that everybody's entitled to a fair trial, and not people who wear red jerseys or blue jerseys in one political party or another. And Amendment 80 to our Constitution has set that up, and that's what I try to honor. I'm married for 37 years, got 2 kids, 4 grandkids, and I'm a Methodist, so I'm home.
Okay, we will begin with you, Judge Welch, with this question. Have you ever woken up in the middle of the night thinking about a case and wishing you had done something differently? If so, describe this situation.
Well, I've been a lawyer for 45 years. How much time you got? I've got 2 minutes. I've waked up many times thinking about cases that, as an attorney, and wanting to do things differently. I did the first case against a Catholic priest in Arkansas for a woman named Kim Phillips about 25 years ago, and we got a verdict against the priest, but it was uncollectible because he'd taken a vow of poverty. And Kim, God love her, had a stroke shortly after I represented her, which was unusual for somebody her age. And I wake up in the middle of the night still wishing that I could collect that $1 million that the jury gave, thinking they were giving her some relief. As a judge, I wake up constantly second-guessing decisions that I have made. But you have to learn to make your decisions, to be consistent, to follow the law and the Constitution, and do it all the time and go back to sleep.
Thank you for your response. Would you like me to repeat the question? The question is, have you ever woken up in the middle of the night thinking about a case and wishing you had done something differently? If so, describe the situation.
Well, I can point to a case. I sat as circuit judge in Saline County. I was appointed by the governor to fill a judgeship where the judge had failed to pay taxes for over 15 years. And so I went in to clean up his docket and to help restore respect to the justice system in that court. And I handled a lot of domestic and family cases. And to me, those were very difficult cases because I was deciding custody cases. I was dealing with abuse. I was dealing with both child abuse and family abuse. I know one case where a lady came before me wanting an order of protection against her husband. We left that order in place because of a divorce. 2 weeks later, he met her at her front door, pulled up her hair, and shot her through her mouth, through the back of her head, and then turned the gun on himself. Those are the kind of cases that keep me up at night. And I felt as a judge I did everything in my power to keep that gun out of his hand, but he still chose to do that. Now, the good news is she survived and he killed himself. So those are tough cases, but those are the type of cases that we as judges have to hear. I was also an elected prosecutor, and those cases were also difficult because I had to hold the hands of parents and grandparents who had lost their children to murder and drugs. And I spent a lot of sleepless nights trying to make sure justice was restored to Saline County after Dan Harmon and his corruption and his shenanigans put people in prison that didn't belong in prison and let people out that deserved to be in prisons. So that's why I'm running for Supreme Court.
Thank you both for your responses. This next question is for you, Mrs. Webb, and this is for Supreme Court nominees. When is it appropriate to overturn past precedent?
I think it's important to overturn past precedent when things have changed in society and things have come to the attention of society that have been wrong in the past. We've seen our Supreme Court move in a significant direction away from incarceration of juveniles for life and away from the death penalty for juveniles, which I think is a good thing. I think the juveniles are the one part of society, or one of the parts of society where we have a chance of restoring and rehabilitating. I think those are the type of precedents that we saw that happen with race discrimination on our schools. I think it's with new technologies and new scientific discoveries, The Innocence Projects are teaching us that DNA testing is getting better and better, and therefore I think when a defendant asks for a retest on a DNA case, that's something a Supreme Court should look at closely. I served on the Supreme Court as a special justice in a death penalty case where the defendant asked for DNA retesting, and I'm proud to say as a court we gave him that chance, because if he's facing the death penalty, he should have every opportunity to prove his innocence.
Thank you for your response. Would you like me to repeat the question for you?
No, I think we always have to be careful running for the Supreme Court to answer questions which put us in a position where we might have to recuse later. The last time I was asked to serve on the Supreme Court, I had to recuse because I had written an article about just the defendant who was before the court. And so when you talk about past precedent in general, there are things that we know deserve to be changed. Plessy versus Ferguson was past precedent, but the United States Supreme Court determined that we couldn't have separate but equal anymore in our schools. In the Constitution and interpreting the Constitution, sometimes we have to look to the language and determine whether or not a statute that's being interpreted or a case is grounded in the language, the strict language of the Constitution. But, you know, you have to remember that the Arkansas Supreme Court doesn't deal with a lot of the hot-button issues that we talk about. Those are the U.S. Supreme Court's province, and we're bound by the Supremacy Clause of the Constitution, the United States Constitution, and we take an oath to uphold the United States Constitution. So what we deal with more often is the Arkansas Constitution, with highway funding, with questions having to do with with schools, Lakeview. Those are the kind of cases that your Supreme Court justices have to be conversant in more often than whether or not they're going to take care of the guns and abortion questions that most of us get when we go to these forums.
Thank you so much. At this time, are there any pre-approved questions from the audience? There's Osiris. Everyone say.
Everybody thinks you wrote all these.
I know. Osiris did not write all these questions.
Yeah, I only slipped in a few. So I know personally in 1995, Wilson versus Arkansas, that is a case that basically said police had to announce themselves when they were executing a warrant. Recently, we have in our city in particular, a lot of lawsuits with people's rights being violated by no-knock warrants. So speaking from the perspective of how we can work with the Arkansas Constitution, what can be done in the Arkansas Constitution to make sure that these warrants have more legitimacy and are comprehensive so that they're not terrorizing people of color and poor people?
Judge Welch.
Well, no-knock warrants are not favored anymore, and one of the reasons is because of what you're describing right here. They're clearly used more in neighborhoods of color. They always have been. Now, no one wants to think that they're racist, but people have a bias often against things that they're not familiar with, and if you have a constabulary that is mostly Caucasian that is executing warrants, there's a danger that they're going to be more afraid of the warrant they execute in an African-American neighborhood than they are in their own, and so they tend to default towards using more force or coming in unannounced. I think that it is imperative that the court scrutinize strictly, and this is something I learned from Judge George Howard for years, is you have to be persuaded before you allow any kind of warrant like that that there is a danger that has to be obviated by the use of a no-knock, and in most cases it's just not true.
Thank you. Unfortunately, we are out of time for that question. Would you like the question repeated for you? Okay.
I hate to ask him to do it, but I think I know it, but go ahead. Come on.
Yeah.
I'll try to shorten it a little bit. Basically, is there anything that can be done with the Arkansas Constitution so that these no-knock warrants are more comprehensive, they're legitimate, and we're not basically terrorizing people because of their race or because of their income in Arkansas?
Well, I would speak to that question and also to something that was mentioned earlier. I would disagree that I do believe that the Arkansas Supreme Court does address significant constitutional issues in its cases, and specifically in criminal cases. We are controlled by the U.S. Constitution, but the Supreme Court of Arkansas is the final say on what the provisions of the Arkansas Constitution says, and they will be deferred to by the other courts. So, but as to the specific question, I think the Supreme Court does address those type issues, and I can't speak on a particular case, but I can assure you as a Supreme Court judge, I would consider all of the rights that are guaranteed in the Constitution to protect and the presumption of innocence. And if it's a procedure that is not respecting that presumption, and if it's a procedure that's impacting a part of the population in a discrimination manner, that would violate the Constitution of Arkansas.
Thank you both for your time, for being here today, and thank you to all the candidates at this time. That is the end of our Judicial Candidate Forum. Thank you for being here and being invested in your community.
Let's give Laura a wonderful hand for taking care of our business this afternoon. We also want to say a special thanks to our ladies in red, the Delta Sigma Theta group today. Some of our candidates have hung around, and we're going to encourage you, if you didn't get your question asked here, that you'll visit with them during the completion of this. Thanks to all of the candidates, thanks to all of the sponsors for this event. There are so many other things that will follow. We're going to encourage you to watch your websites and watch your Facebooks and all your social media as we begin to do other things around the month of March as we do our normal Rights After Wrongs. This event has been live streamed. So you didn't just have the audience that's in this room. You had those who were able to join us through social media. So again, thank you to our candidates. We wish you the best, and to all of our sponsors, and especially to Laura Monteverde. Thank you.